you asked me to come to a presentation. I threw out a couple of topics, and the one that I thought would be most interesting and useful to you is a short talk on intellectual property. Now, I'm not a lawyer or any kind of subject matter expert on this, but I have become exposed to a lot of it in the last year because I'm interested in commercializing my research. So I've had to learn a lot about intellectual property rights. So we're going to go over what intellectual property is and how it's supported around the world. For those of you who've taken 320 already, there'll be a little bit of redundancy there. They'll probably be exposed to all that already. Then I'll talk more about how it pertains to computer science specifically. A little bit of the history, how different events have unfolded over the last few decades that give you computer science, intellectual property today, so how it's relevant to you. And then finally talk a little bit about current events and what's going on in patent law and intellectual property, so that when you read headlines, you can be a little bit more informed about what all of these things mean. So first off, the types of intellectual property. You have copyright, patent, and trademark. And then you have something that's kind of intellectual, it does have legal precedent, is trade secrets. So copyright is simply you have created some kind of creative work, either a picture, a story, a song, something along those lines, and it's yours. Copyright happens automatically. If you made something, you have the copyright on it. If someone contests you on it, all you have to do is prove that you made it. Then you have a trademark. That's Nike swoosh, it's a trademark. Golden Artist, it's a trademark. They register these with the patent office, and so long as it's recognizable and distinct from all the other trademarks, they get it. It doesn't have to be innovative, there doesn't have to be any creation of anything really. It's just this is what I use to identify. And now this isn't so much that it's their creative act, but it's their brand. So no one else can use their trademark, so that whenever you see the golden arches, that's McDonald's. Anytime you see the Nike swoosh, that is Nike. So if anyone copies that, that's trademark infringement. It's like, okay, they're trying to sell it as a Nike shoe when it's not. Trade secret, this has applied in the past to recipes and all things like that, where you can't patent or copyright them. And it's just, you keep it secret. Your intellectual property is, I kept it secret, so it's mine. Now, if another company reverse engineers your trade secret, you have no protection. But now there's a particular legal way that reverse engineering has to happen. You going and getting somebody from their company and finding out what their trade secrets are, that's not reverse engineering. There's very specific guidelines on how to do black box, clean room reverse engineering. But for instance, a lot of the specifics on Google and Bing's, how they agglomerate their different search algorithms, that's not patented. Although a lot of the individual algorithms are patented, the total system is just trade secret. How much to weight each type of thing, they don't tell anybody. And so one company can reverse engineer the other. Then we get to patents. For a long time, computer science, patents weren't relevant to computer scientists because programs aren't patentable. That is the legal precedent to this day. An algorithm is a mathematical function. This is not a creative act. You're just writing an algorithm is writing a function. So legally, technically, the precedent is that algorithms are not patentable. Well, in the 80s and 90s, a couple of judges said, that's absurd, that's just silly. It's obvious that these computer scientists are in fact creating something useful just in the way that Eli Whitney created the cotton gin. Microsoft creating Windows is a creation. So a couple of court cases in the 80s and 90s set precedent. And it made for the interesting turn of events that I've come to find out recently. When you write a computer application patent, you have to talk about it like it's a machine. You have to talk about the different mechanical aspects of what it's doing. It's really just writing about a computer program as though it were a cotton gin. And that's how you have to write a software patent. Because if you just straightforward write what your program was, that's an algorithm and that's not patentable. So it's a weird conflicting case where you have precedent saying an algorithm isn't patentable, but you have precedent that's saying anything realized in machine form, i.e. a mouse and a screen, that's a machine, that accomplishes a goal, then it is patentable. So because of those two conflicting precedents, you have to write software patents as though your program is a physical machine doing something. So we get to how to actually get a patent. Well, the U.S. Patent Office accepts applications, and they cost $2,500 to, as of the last time I checked, it was $2,500 to register a patent, or to apply, not to register a patent, so you register trademarks, to apply for a patent, which may or may not be given. Now, the reason it costs so much is they have people at the Patent Office who will take it, and they will go and do domain research. They'll go and find out if anyone's ever done anything like this before. There are only really, now, not a lawyer, there are more but two general requirements is that your patent has to be novel. It has to be something that no one has registered as a patent before. It also has to have not been in the public domain. And the patent that you describe has to actually say how to do what your thing does. That's the original intent. The whole point was to keep things from being trade secrets. The U.S. Patent Office does not want you to have a trade secret. They want your information to be in the public domain so that other people can use your program and pay you a licensing fee. But your patent has to say how to actually do it. Being vague and saying, well, it does some stuff and it sorts the list, that doesn't count. You have to actually say what your sort algorithm is. And you can patent all kinds of stuff. And I'll get to a little bit of the absurdities and abuses of the system later on. But so long as there is not an existing patent, so long as the information is not in the public domain, and so long as your patent actually describes how to do what your invention does, you will get the patent. Now there's all the process of making sure your patent correctly references all the things it needs to reference. That's where the application fee goes to. It's the person who's looking it all up. Now you can write your own patent and submit it on the back of napkins if it's formatted in the government and it has the right forms along with it. But you're probably going to want to get a patent attorney to write it for you because a patent attorney knows how the legal language works. What you don't want is to write something that puts essentially your application into a place where anyone can get their hands on it, but the way you wrote it doesn't say that the important part is exclusive to you. It's possible that you might file a patent thinking that you are patenting a new chip design for a smartphone, and what you actually patented was how that smartphone looks because you wrote the patent wrong. So that's why you go with an attorney. Now, from what I've been speaking with attorneys locally and in Texas, it will cost about $15,000 to patent something. Now, the initial fee is actually only $250. So if you have something, you have a patent and you have a prototype, but you don't have money, but you want to get that patent in, you can apply for something called a provisional patent. Now, what a provisional patent does is it holds a date, because especially with the recent passage of some reforms on the Patent Office, it is no longer first to invent. For the longest time, the precedent was the first person who invents it gets it, same as copyright. First person who writes it, they have the copyright with patents, the first person who invents it gets it. That is no longer the case. It's the first person who invented it to file a patent that gets it. So if you invented something last year, and I legitimately invented the same thing today, and I file my patent before you do, I get it, you don't. So a provisional patent is useful for holding a date when you don't have the large amount of money required to actually apply for a full-fledged patent. Now, in a patent, there are things called claims. Now, these are the things that you are saying you are patenting. In very specific, you claim this system that does this way, I patent that, after having described how the system works. Well, a provisional patent doesn't have any of that. It just describes the system. That's all a provisional patent does. Describes your algorithm, describes whatever you invented. and you fill it out, do the correct forms, all that, and you mail it to the patent office. They put that envelope in a drawer. They do not open it. They just stamp the date when they got the envelope and put it in a drawer. Later, when you do, within a year and a day, you have a year and a day to file a full patent from the date you file a provisional patent. What they do when they get your full patent, you reference the provisional you sent in before, all right? At that point, they'll take the patent you just sent in, and they'll take that envelope out of the drawer and they'll open it. And then they'll read both documents. And if the patent officer believes that the patent you sent in for a full patent talks about the same system that your provisional patent did, they put the date from the provisional on the full patent. If they don't believe that they talk about the same system, the patent application gets the date that it showed up at their door. But that's the only purpose to a provisional patent, is to give you a date. And usually the most common reason for using that is if you need to get money. If you don't have the money to file the full one. So it gives you time to find investors, find capital. Now, the way that patents work, I want to clear up two terms to make sure that you all understand what these two terms are. Defensive patent and patent troll. These are two terms that fly around a lot. Not everybody knows what they mean, and some of them actually think the first one is the opposite of what it is. So first off, now that I've talked about what a how to do a patent and how to get a patent, I'll tell you about what a patent actually allows, what protection it actually provides you. What a patent does is it ensures that no one else can make your invention. It does not give you a right to make your invention necessarily, but if you successfully patent something, no one else can make it without your say-so. That's all a patent does. It's quite possible that there's some other technology that your patent uses, like your invention uses, that it's kind of, built on top of. And you have a legitimate invention, a legitimate patent that happens to use a prior existing patent. If the person who owns that previous patent refuses to license it to you, you cannot legally make your own invention, but nobody else can either, including the guy who holds the first patent. So the incentives are set up, though, to where they probably, people refusing to license their patents happens rather infrequently. People charging insane prices to license their patents now that happens reasonably frequently. But the system is set up to discourage refusal of license. Now, what a patent troll is, it's Nathan Myhrvold's, but there's a whole bunch of them out there, actually. He's just one of the biggest and most famous ones. And they own companies. Now, people use patent troll as a strictly negative term, and that, I think, is a little bit off. It's not strictly negative. They are contributing the patents. But what they have is they have an office, and it's staffed with people who think. They think up ideas. Every day, they're a think tank. And they write down every idea they get that might be potentially commercially viable product, and they patent it. They patent every idea they get. And they don't make any of them. Not a single thing. That's the key to a patent troll firm versus a true invention firm. Patent trolls make nothing. They make patents. Then they wait. Because now that they've put that idea out, and this is a lot of their motivation or their self-justification. They put the idea out there, but they don't have the facilities to make it. So they want to partner with someone who does have facilities to make the invention that they came up with. When they find their partner, the partner manufactures it, uses infrastructure, and gives them a royalty fee for having invented it in the first place. That's their story. The other side is they patent obvious ideas and then sue the heck out of anybody who uses them. Because that, and brings us to the second one, defensive patent. There is no such thing as defending your stuff with your patent. There is attacking somebody else's stuff with your patent. So when you hear about Google or Apple or Microsoft wanting defensive patents, what that means is Apple has patents, Google has patents, Microsoft has patents. And they want a Cold War. They want nobody to be licensing each other's patents, or at least they don't want to be licensing the other guy's patents. And if they can, they want the other guys to be licensing theirs. So you get as many patents as you can, so that if they try to make you license one of their patents, you can try to make them license one of yours. Patents can be defensive in the same way that missiles can be defensive. They deter other people from shooting theirs. So now that brings to a little bit about what's going on in the mobile world right now. Because that's where a lot of the news is hitting. And it's between those three companies, mainly. Well, you also have HTC, Verizon, Samsung. They're all players in the game too, but again, making the Cold War metaphor, they're the proxies. It's more or less Google and Apple fighting it out on the big through proxies, which are the actual handheld developers. There are several bodies that register patents, and they have jurisdiction over a certain area. Three of the main ones are Japan, the United States, and the European Union. They each have separate patent offices. If you patent your invention in America, an inventor in Japan can build it and sell it in Japan without paying you a dime, unless you register a patent in Japan. Same with Europe. And all three have different rules. For instance, provisional patents don't work the same way. That's what the version I gave you, that's American provisional patents. They do not work the same way. And especially with something called prior art. I totally skipped that earlier. Prior art. Prior art is when it's out there already. No one else patented it. It's not anybody else's invention, but it's out there. People know about it. So, for instance, I couldn't go and patent cups. No one has a patent for the cup. It's not but you can't patent it. People know what cups are, people know how to make cups, people know how to use cups. It's prior art, prior existing. And in fact, that came into play with the iPad suit. I'll get to that in a moment. But the idea is, if it's already an idea that everybody knows, or everybody who would care to know knows, then it's prior art. Now, one of the ways that something can very, very quickly become prior art is if you publish it in a journal. So if you are an academic computer scientist and you're doing research, and you publish any kind of thing about how to make your system, you have a year. And if you don't patent your whatever you talked about in that article within a year, it immediately goes into the public domain and becomes prior art. You can't patent it, and no one else can either. So if you don't like patents, if you don't want patents, then the quickest way is just publish everything. Make everything public domain. You establish prior art, no one can patent it, even you. So that's what prior art is, and we'll get to why that's relevant to the HTC and Samsung and Apple story. So a lot of the hot fighting right now in the patents is going on in the European Union. And this is because they have a wider variety of courts, and there's one particular judge in Germany who happens to interpret things a way that Apple likes, and they keep filing stuff there. And it's the same thing. Which court has jurisdiction over a lawsuit? In America, if you file with the patent office, they tend to go to Texas, actually. Texas is where they tend to do their lawsuits. Again, for interesting reasons. There was one recently where a guy basically tried to claim that he had patented the World Wide Web. I can't remember his name right now, but I know that Tim Berners-Lee had to go and testify and say, that's stupid. And I think that was essentially his testimony. He's like, I'm Tim Berners-Lee, that's stupid. The patents, see, the thing is, the dude did actually have patents on ideas that actually were essential to the World Wide Web. And he sued. He sued everybody because he claimed he owned the patents to the web, which he did. He had the patents and they were essential technologies. So when he sued, they had to go in and prove that the patents were awarded incorrectly. They went and found some research that had come out of UC Davis, I think. It was one of the UCs that was essentially pre-existing to what that guy did, and that their lab had published the results, and thereby finding that the patent was illegitimately awarded, that the stuff was in fact prior art. Now, a lot of the stuff for instance, Samsung Galaxy Tab. I don't know if y'all had heard, for a while you could not buy Samsung Galaxy Tab from Samsung in Europe. And that was because a German judge had ruled that it violated some iPad patents about interface and how the system is designed. One of Samsung's defenses, who in here has seen 2001: Space Odyssey? All right. Have y'all seen how they have nice little flat rectangular computers with touchscreen displays in? Yeah, they claimed that that was prior art. That was the step that invalidated the iPad's patents. That helped. That actually held up as an argument, and I think a higher appeal court than just said no. But it's things like that. Now we get to patents that just probably should not be awarded. Cats. Any of y'all play with cats? Like cats? Cats fun. Anybody ever use a laser pointer? Let the cat chase it? Anybody seen the patent for that? There's also a patent on how to swing your kid on a swing set. There are all kinds of patents for every possible thing. Now, you know, this one, now I brought up those two as obviously absurd. I consider this third one just as obviously absurd, and so does Google. Swipe to unlock. You have a phone, swipe to unlock it. Apple has a patent for that, and they are actively suing HTC and Motorola because they violate that patent on their Android handsets. I personally think that that patent is absurd in the same category as cat laser chasing. But the fact is the patent office is handing out those kinds of patents. This is one that Lodsys, which is a subsidiary of Nathan Myhrvold's company, holds. You know, when there's some kind of mobile application, and there's a paid version and a free version. And if you have a free version, you play it, and every now and again a little pop-up comes and says, hey, you want to upgrade to the full version, you get more levels, more features, blah, 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 blah. There's a patent for that. Lodsys owns that patent. The idea of a pop-up coming up in a free application to advertise for the paid version of that same application is a patented business process. And they use it to sue people. When app developers make apps that have that functionality, they sue them. The response is, and here's the thing, they sue them for a small amount of money. They make the amount of money that they are suing them for obviously less than legal costs. So, even just from a business perspective, you have no incentive to fight. It is cheaper to pay them the licensing fee. And that's how patent trolls make their money. So, let me see what else. That's hit the main points. I was kind of hoping that y'all would have some questions or possibly discussion on the topic. Yeah?
What you said about prior art, how long, that doesn't apply to, say, the things that Xerox PARC made and that are still regularly used, and I think patents and lawsuits still go on about them, things like...
Well, no, prior art would be something...
something for the public.
Well, no, I mean, anything that's in the public domain. So if somebody writes about it in a book, if somebody writes, like in any way, shape, or form that they enter it into the public domain. Now, if I have a conversation with you, I am giving IP exposure. I'm no longer privy to my information. So there have been patents, like if I came today and talked to y'all about my dissertation and how my programs work, that could be argued by a competitor that that was me establishing, putting it into the public domain, and that would establish prior art. But all of this hinges on somebody else contesting somebody's claim. Now, as far as things that have been previously patented, that is a form of prior art, but it's not the same type because it's just someone else owns the patent already. You can't patent something which is already patented.
Well, did Xerox PARC, I thought they didn't patent a lot of the things that now, like Apple or Macintoshes and Windows and everybody's fighting over. So since they didn't patent it, it doesn't enter public domain anyway, even though they produced things that may have used it?
Well, no one is fighting over the types of ideas that Xerox put into the public domain accidentally. Like a windowing system, no one's fighting over that. people are fighting over, it gets kind of absurd. Things like dedicated windowing systems to alert to battery failure. You know?
Okay, so it's nothing general, it's something very specific.
Yeah, but the thing is, you have these companies with billion-dollar cash bankrolls, and they just file everything, every idea that any tech who works for them makes, like, you know, the little window that comes up to tell you your battery's dying. That is patented. You know, like I said, swipe to unlock. That's a very relevant, important. The ability to have interactive wallpapers on a touchscreen device. These types of specific, yet obvious ideas are patented. Someone owns it, someone licenses it to other people. And this is the state of affairs. And it's largely the motivating factor behind Google acquiring Motorola Mobility. I don't know if you all heard about that, but that has gone through. Google bought the subsidiary of Motorola that was responsible for their handheld devices. And this was because Google was getting sued-ish through their business partners. But prior to that acquisition, Google only held 1,000 patents, give or take, you know, right in that neighborhood. And most of them weren't used by any of their competitors, especially Apple. Microsoft used some of them from them, but since Apple wasn't in the search business, Apple didn't use most of the patents that Google held prior to last week or week before last. So when Apple would sue HTC or Samsung, which are kind of established business partners of Google, Google had no way to help them fight back. At one point, Google did find 4 patents they had, and they gave them to HTC. And HTC then used them to countersue Apple. But they bought Motorola Mobile for a very large amount of money that I can't remember right now, but billions of dollars. They were just like, okay, we have all this cash lying around, we're going to buy a patent library. They're like, oh, we get a phone company along with that patent library? Awesome. But both the European Union board and the US board had to review the company acquisition, since Motorola Mobility is registered as a company in both the European Union and the United States. Both gave their approval either last week or the week before, and they both gave riders. They were like, we approve this, it doesn't infringe anything, but we're watching you. But, so that they expect to file antitrust stuff against Google, essentially, because they're expecting Google to sue Apple using the patents in a way that they feel it would be non-fair and competitive. Oh, that's another term that gets thrown around. FRAN, fair, reasonable, and non-discriminatory. Anytime you have a standard, like 3G wireless, that's a standard that is used by all phone companies that compete with each other simply because you don't want to have 20 different types of cell towers. That would not benefit the companies, it would not benefit the consumer, it would not benefit anybody. I mean, imagine if we had 20 times as many cell towers as we currently have. So all of the companies agree to abide by a standard. Sometimes those standards use patents, use patented ideas. The companies who own the patents that are adopted as standards, they agree to license their patents to anybody. They will not discriminate, they will license to anybody, and they will license at fair and reasonable prices. That is the problem with fair, reasonable, and non-discriminatory licensing, though, because what's fair and reasonable? And that has come up recently. Motorola tried to sue Apple for infringing FRAN patents in Europe. Apple claimed that the requested price that Motorola had made to them was not fair and reasonable, and a judge agreed. So it's kind of just, what does that particular judge think is fair and reasonable? But yeah, so a lot of the patent system is, in my opinion, just a wee bit broken. It works though. It does in fact work. I mean, inventions are being made, they are getting licensed. And the patent office is one of the very few, along with the post office, establishments that's in the Constitution. You know, and it is there, and it's a good idea. I'm not up here trying to say, no intellectual property, information for everybody, yay, no. But the system does have a lot of loopholes in it. For instance, one example I was given about the defensive patent thing. If somebody owns a patent for a chair, and you invent the rocking chair, you can't make your rocking chair unless the guy who owns the patent for the chair lets you. And that is one of the problems with the system, is that all it takes is one person to say, I'm taking my ball and going home, and it shuts down the whole thing. So, anybody have any questions, or, yeah?
Do you see a winner between Google and Apple, or do you just see a 10-year growth in that?
Well, with the current system, it's set up to where everybody sues everybody. And eventually, all of the proceeds from iPhones are going to Google, and all of the proceeds from Android handsets are going to Apple. So they start rooting for each other. I mean, like, no, really, that's the absurdity of the system. You can't sue them for more than the cost of the device, but you can sue them for up to the cost of the device. So, the absurd conclusion of the system as it stands is proceeds of iPhones going to Google, and proceeds of Droids going to Apple, and then rooting for each other's products. That is the absurd conclusion of how the system works right now. I honestly think it's going to break. I think the system will crash under too much litigation. Because eventually, 50% of all of the cost of handsets will be licensing fees. And that'll get to the end user, and at that point people are like, I don't want $3,000 phones. And there will be a bottom-up incentive to actually, yes.
Are there time limits on patents?
They kinda-ish, but the problem is corporations own patents and corporations don't die. Because a lot of the precedent and laws concerning when a patent is invalid has to do, but functionally no. Functionally, once someone patents something, they got it for life, forever. And especially with the business cycle, the patents which do expire aren't relevant, like, because they're so old. Innovations on handsets from last year aren't relevant anymore. I mean, there are patents that were applied for last year that haven't been granted yet that are no longer relevant. And that's another thing. The patent process takes upwards of 5 years. So 3 to 8 years is the window from the date you apply for a patent when you can expect to get it. So with that type of cycle, if you're giving a very specific type of patent, you won't get it until after it's irrelevant. And you'll have to go back and sue people for using your invention during the time when it was relevant in order to get any money off of it. Yeah, no. If you apply for a patent today, someone else makes a product tomorrow that uses the technology you applied for the patent for today. They use it for 2 years, then they discontinue usage of it. Then a year after that, you get the patent, you can go back and sue them for a percentage of the profits that they got during the 2 years after you patented it. Wait.
Sorry if this was answered in the first 15 minutes or so I missed, but I've spoken with other people. They feel that a lot of the problems in the patent system are inhibiting, I guess, innovation and progress, because like patent trolls, as you said, will kind of shut down or at least severely hamper small companies or businesses trying to form. Would you say that would in any way contribute to hopefully the system, like you said, getting too ridiculous and something more reform, or would you say that's not a real problem?
Okay, well what you're talking about is hard. Things not getting invented will not cause change, because no one knows what things didn't get invented. What will cause change is if things that people want and currently have access to become too expensive, or if the courts become involved. If every court in America that has an appeals judge has 1.5 years worth of patent suits on their desk, things will change. Now, how long it'll take to get there, will it get there? But if I had to guess, and this is a guess, the way this will eventually play out is that the system will work too inefficiently. It's just not built to handle. The system that was designed in the 1890s, actually no, excuse me, not 1890s, in the 1790s, is not made to handle the information age. An alternative system would probably be something like the standards system, where you have standards bodies, but I don't know. I'm not going to speculate on what a better system would be because I don't know. I don't have the legal expertise. But I do know that the current system, for no other reason, that it takes multiple years to get a patent on an invention that might be irrelevant next year. So there are a lot of problems, and the amount of money that's getting thrown at the problem, I think somebody will fix it somehow. Okay.
I have a question on what you just said there, but so so you talked about, so you can make a patent and then someone else can start producing it, and then, once it 5 years later, finishes, you have the rights to what they did there. So does that mean, but you also said something about, when you have a patent, it doesn't give you permission to make it necessarily.
Mm-hmm.
So if you patent an idea, from a business perspective, you patent an idea and you're not going to really own it for like 5 years because it won't finish or whatever, you could start making it then, right? You just might run the risk that someone else holds the patent or that you won't get it or something.
Okay. You should know, the day you file the patent, you should know whether there's another patent or not. You shouldn't file, because of the expense, you do not want to file a patent that there's an existing patent for.
Yeah, okay.
There's just a boatload of reasons you don't want to do that. So the scenario where you don't know if someone else holds the patent, you shouldn't get into that.
So most times it is, you'll patent something or you'll submit a patent and start producing it even though it hasn't been granted yet.
Yeah, that's what I plan to do. I know that no one has an existing patent for my research because I'm doing it. And even for the academic perspective, you have to do novel work in order to get a PhD. So it has to be something no one has ever done before, not only something that no one has ever patented before. So from that, I know that it is novel. And I do plan on starting producing the product way before I have it actually granted the patent, but not before I apply for the patent. That's one of the things. 18 months in, you have an 18-month grace period from the day you file the patent. 18 months after you file the patent, it gets listed in the patent registry as a pending patent, which means anyone can go and read it. Anyone can go and read your patent on how to build the system, build it, and start using it before you can sue them. Like at the 18-month mark, you show up to court and say, I want money from them, and the judge will say, come back when you have the patent. But at that 18-month mark, that's when it goes into the public domain. Now, the way it normally works is if another company wants to license it, they work out the licensing agreement with you right there so that they don't get sued 4 years later once you have the patent. Because having a judge decide how much they'll pay for the licensing agreement is not what most companies want. Most companies want to negotiate a fair and reasonable licensing agreement. Like I said, the system is working-ish right now. People are inventing things, people are producing those inventions, and those inventions are being used by end consumers. So the system is, in that sense, working. There are things that people can see as obvious problems with the system, and some people think that those problems will compound and majorly impact. Now here's the thing, if these problems, if patent trolls never actually have a major negative impact on companies and consumers, they'll never get fixed. So, I don't know whether you should hope they don't have a bad impact or hope that they do. But that's what's going to drive change, is actual impact of these different problems in the patent system. if Google is able to keep being profitable with their operating system, and if Apple is able to be profitable with its operating system, they're never going to actually try to change the patent system. And they're the people with the money, they're the people with the power. So unless one of those major players want to change the patent system because of measurable effects on their bottom line, it's not going to happen.
You said you didn't want to apply for a patent that someone already had. In terms of, I guess, interpreting who has or doesn't have a patent on some idea, you said after 18 months after you apply for one, it's free for everybody to see, but do you, or should you, I guess, have like a patent lawyer of some sort interpret what is?
You should have a patent. So the first step, okay, the first thing a patent lawyer will do is do a patent search. They'll go onto the database. There's a publicly accessible database. In fact, you can go to patents.google.com. Google has a front end to the patent database, and you can search. And I mean, the patent office has their own search interface, but Google put their own front end to it also. And you can find out if anyone else has patents on the types of ideas you're looking for. And I mean, when I say that, I mean, there are tens or maybe hundreds of millions of patents. There's a lot of patents, and they are on everything you can possibly imagine. So you do. That's the first thing a lawyer will do. They know how to search the system efficiently. And you bring them your patent, they'll read it. That'll be the first thing they do. They read your document. Then they'll go and do a patent search and find out if there's existing patents. One of the reasons you don't want to submit a patent that there's already a patent for is because it will get rejected. But there might be something in your patent that is patentable. So you might describe a system that does in fact infringe a different patent, but there's this one little part of it that doesn't. And if you had just submitted that little part, you'd get your patent, but it gets rejected and the idea is out there for anybody else to apply for it who wants. So that's why if you're interested in patenting your programs or inventions, the first thing you need to do after you write down what your system does is go talk to a lawyer.
Assuming you get a patent lawyer to look at your thing, it's the situation you described. You have a system, but only a small subset of that system is potentially patentable. Hopefully your patent lawyer would be nice enough to tell you that, but
Well, that's what you're paying him to do.
well, no, never mind. I guess that, assuming he's paid, I guess that's all that.
Lawyers don't like getting sued for giving you bad legal advice. Yeah.
Let's say, after you publish your work, you said you have a year to submit a patent on it?
No, that's in the United States.
Okay.
The European Union and Japan have different policies, and I don't know what they are.
Okay, but if you submit your patent in the United States and it fails after a year, then are you just shit out of luck? Can you not reapply for? Can you not apply for it again because it's been a year?
Okay. See, that's one of the tricky things where, like, if your patent gets rejected, you're not going to be able to reapply. Period.
Oh.
I mean, you'll need to write a different patent for a different invention. Now, that might be a subsystem, a sub-part of your patent. But now, here's the whole thing isn't just a silent yay or nay, gladiator vote. It is a cooperative process between you, your attorney, and the patent officer. The final document that gets written will have at least 3 authors. Now, you'll be the inventor, but your lawyer will have written large parts of it, and the patent officer will have written parts of it. I mean, like, for instance, if there's some other invention that you didn't know about, that it is, held on some small part of your system, the reference to that will be, like, the patent officer will probably send your lawyer an email going, hey, found this patent, you need to include this in this section, And so the final document, that's one of the things. The inventor may have never read the final document that gets approved, when it gets approved. Hopefully they go back and read it after it's approved, but, yeah. Go ahead.
No, go ahead.
No, that's it.
Okay.
I was gonna ask if anybody has ever tried to patent a patent office. I tried looking it up.
It's an interesting idea. But I mean, no, a lot of business processes, they're allowing patents on business processes. So, maybe, I don't know.
It's gotta be prior art.
I might ask about the business processes thing, but before that, it's kind of what Kenny had described. If you don't apply, well, assuming you do apply for a patent and it somehow gets rejected due to, I don't know, misinformation or just bad luck, is there some kind of double jeopardy system, or if even a subsystem of what you tried to apply for could have been patented and you try for that, they're like, nope, double jeopardy, you already tried, get out?
Well, no, like I said, it's a collaborative process. So if they say, okay, this half of your system is patentable, but this half isn't,
It'll get edited.
yeah, it'll get edited down to be
Okay.
that half of the system. But you still don't want to be in that situation if you can, because it's already a very long process that incurs more legal fees, and you might get a patent officer who is a bug and does just give the thumbs down and send it back to you. But from what I've been described, it's a collaborative, ongoing process. It can just get very expensive if you didn't do it right the first time. So yes.
Is there any way as a small developer to protect yourself from patent trolls?
No.
No.
No,
I was afraid of that.
because they're asking for so little money, that it's not, it would take someone with a bankroll to take a loss and fight them. That's what it would take. And that would have to be if they're bleeding them in enough different places to where making a single suit or bringing a class action lawsuit or something along those lines would make it worth time. But as I currently understand it, no. There's no way for a small developer that does not have a substantial legal department to successfully fight patent trolls. Your best case is to call their bluff. If you are a small developer and you don't want to or can't afford to pay their licensing fees, call their bluff, don't pay them, and let them take you to court if you want, and then just show up without a lawyer, and then let the judge have what they want. But a lot of the small developers just pay the licensing fees because it'll be something like they'll ask for $25 a year licensing fee, but they ask that from 1 million people.
Yeah.
What if you use a patent but you don't make any money off of it?
What do you mean?
Like, say you're a small developer and you develop an app that you put up for free,
Hmm?
say.
There's no reason to patent it. Unless
No,
you're,
but if you use a patent.
what do you mean if you use it?
It violates my.
Oh yeah, no. You can, if someone else patents it, you cannot use it without licensing it from them.
Well, no, if you, like you said, the battery low pop-up
Mhm.
was patented. What if you use that but you don't charge for it?
But the person who owns it does.
They can still charge you just for having it.
I mean, like, if you go into McDonald's and take all their burgers and give them away for free, you still stole their burgers.
Good, that's a good analogy.
What if it's an open source effort and you have there's no clear owner? Using.
Well, open source is a form of licensing, and open source is one of the ways to enter prior art. If you license a program using an open source license, you are essentially entering into the public domain and establishing prior art on that software. Yes. All right, well, thank y'all.